you don't know me, my name is Lorna Sharpstein. I'm president of our chapter of the Federalist Society. So we're a student chapter of the national organization. We believe in promoting challenging, intellectual, respectful discussions that often don't happen in classrooms. So we achieve this through events such as this one, usually with an invited conservative or libertarian speaker and a faculty participant. We focus on current events and legal issues. So first, our invited speaker is Professor Josh Blackman. He's an associate professor of law at South Texas College of Law in Houston. He specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Josh is the author of 3 books, and he was selected by Forbes magazine for the 30 Under 30 in Law and Policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He's an adjunct scholar at the Cato Institute. He's also the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy league.
You should all play.
And blogs at joshblackman.com. He's the author of over 4 dozen law review articles, and his commentary has appeared in the New York Times, Wall Street Journal, Washington Post, USA Today, LA Times, and other national publications. We're very fortunate to have him here with us today.
Thank you.
And then Professor Tuan Samahan teaches and writes in the area of structural constitutional law and transparency. His articles have been published in the Stanford Law Review, Ohio State Law Journal, the University of Chicago Legal Forum, among many others. One of his recent articles defends the prerogatives of statutory jurisdictions on federalism grounds. Sanctuary jurisdictions, I apologize. Beyond his scholarship, Professor Samahan is engaged in interpreting federal constitutional law. He has testified before the U.S. Senate Judiciary Committee, served as counsel in separation of powers and Freedom of Information Act litigation in federal trial and appellate courts, and taught federal administrative law judges. He received his J.D. cum laude from Georgetown University Law Center, where he was an Olin Law and Economics Research Fellow and co-awarded the Olin Prize in Law and Economics. Prior to entering teaching, he clerked for a U.S. District Judge on the Eastern District of Virginia and for a U.S. Circuit Judge on the Ninth Circuit. He also practiced in the Washington, D.C. office of Covington and Burling. Recently, he served as a Fulbright Scholar with the law faculty at the University of Zagreb, Croatia. He teaches constitutional law, federal courts, and civil procedure. Let's welcome our guest.
Thank you. Thank you so much. This is a good crowd. Good job. There are a couple seats if you want to maybe try and look around, but for those of you standing in the back, I hope you enjoy the show. The topic today is DACA, which is an issue I think we all generally know what it is. And my position is somewhat unusual. I actually like DACA as a matter of policy. I think this is something that we should enact by statute. I think this is something that actually would serve our national interests in many regards. My position's weird because I think the policy is illegal. I think the way it was enacted was improper. I think the Congress had to do it, not the president. And I also think that the decision of the president to rescind it was valid. So this is a weird space where you say, I like something, but I think it's illegal. And this is something that lawyers often have difficulty with. Far too often lawyers think that their policy preferences and their view of the law match up one-to-one. And one of the good gut checks you can do as an attorney is say, is there something where you think it's really good policy but not legal, or a really bad policy but legal? And one example might be flag burning, right? You may hate flag burning, but you may want to defend the right of people to burn the flag. This is a sort of case like this for me. All right, so my talk here has a few parts. I first want to walk through the history of deferred action, both DACA and the follow-up policy called DAPA. I then want to walk through the litigation that was waged against the Obama administration. Then I want to walk through the litigation that's been waged against the Trump administration and bring you to the present. Next week on Tuesday, so a week from yesterday, the Supreme Court will hear arguments in whether DACA can be rescinded. And we'll get a decision in June of 2020, right before the next election. So the timing is just perfect. Okay. So let's start with a very basic premise. The Congress only gives the federal government power to remove a small number of immigrants, right? The number of people who are here who are subject to removal, they cannot all be removed. It's simply impossible. There are not enough resources to do so. So traditionally, the executive has to exercise what you might call discretion that is prioritizing this group of people for removal over that group of people for removal. And I don't have any objection to that practice. There's other types of benefits that you get when the government decides not to remove you. In certain cases, the government can give you what's called lawful presence, which means you're not here legally in the strict sense of the term, but we're not going to prioritize you for removal. Also, while you're here, you get certain benefits. For example, you can work. You can have a work authorization. Okay. Historically, the government has used this form of deferred action in certain narrow constructs. Let me give you an example. Let's say you were a student at Tulane University in New Orleans in 2005. You were a foreign student. You had a foreign visa. Hurricane Katrina slammed into the Gulf Coast. Okay, now your college is shut down. You're not taking classes, you lose your visa, right? You are not here in the country legally anymore. President Bush, as an act of forbearance, said we will do something special. We will say, if you enroll in another university by the following semester, we will not remove you, right? You can keep your status temporarily. You get to something called lawful presence. And that's, I think, is a good example, right? The person had some sort of status and would get it right away once they resumed university, but there was some sort of thing that happened which prevented them from having it. Okay. Traditionally, that's how deferred action has been used, as a sort of bridge where there was status waiting for someone on the other end of the rainbow, so to speak. Okay, let's fast forward now to 2012. In Congress, a bill is being debated called the DREAM Act, which is, again, a bill that I very much favor. This bill would have given a path to citizenship for certain immigrants who came to this country as minors. Specifically, they came to the country as minors through no fault of their own. They came here, they behaved, they went to school, they didn't get in trouble. By all accounts, they're upstanding citizens, except they're not citizens. That's exactly what DREAM Act would have done. They would give them a pathway to become a U.S. citizen. That bill actually managed to pass the Senate. I'm sorry, pass the House, but was defeated in the Senate. There were not enough votes for it in the Senate. In response, President Obama announced an executive action known as DACA, D-A-C-A. It stands for Deferred Action for Childhood Arrivals, DACA. And what DACA said was that if you were one of these dreamers, one of these people who came here as a youth, you didn't have a criminal background, the government would give you deferred action. They would deprioritize you from deportation. But the government would also give you lawful presence, and that includes work authorization. The exact number of people who were eligible for DACA, who got DACA, is somewhat hard to calculate, but somewhere under 1 million, and we can fight about the exact number, but somewhere around 1 million. We'll just call it 1 million to make it easier. There were a few legal challenges to DACA, but nothing serious. I think because most people actually liked the policy. They thought that, well, this is something that these kids didn't come here on their own. It wasn't their fault. We shouldn't really be punishing them. So this is a very sympathetic lot. Okay. So DACA came out in 2012. Fast forward to 2014. Congress was considering what was called comprehensive immigration reform. Right? This was a bill that would have basically given a path to citizenship to millions of aliens within the United States. This was a very significant piece of legislation. And it passed the Senate. It actually managed to pass the Senate, which was a surprise. A number of Republicans actually went along with this bill. This was before 2016, of course. The bill then went to the House, and the House never brought up for a vote. The Speaker at the time, John Boehner, was afraid that some of his members in more conservative districts would get killed by voting for this. So he just never brought up for a vote, and the bill died. Shortly after the immigration bill died in 2014, President Obama announces another executive action. This one is called DAPA with a P. You have DACA with a C and DAPA with a P. DAPA stood for Deferred Action for Parents of Americans and Lawful Permanent Residents. It should be DAPLR, right? But DAPA was a little bit different. DAPA would have given lawful presence and deferred action to the parents of U.S. citizens and the parents of green card holders, lawful permanent residents. So for example, if you were an immigrant, you came here, you had a child, your child's a U.S. citizen, right? You could now petition to get deferred action based on your child's citizenship. Now, one thing you may not know, if you have a U.S. citizen child that child cannot petition for you to become a citizen until he's 21 years old. So there's basically a 21-year gap between when the child's born and when the child can petition for a green card for the parent. This would have compressed that 21 years to basically nothing, right? If you were the parent of a child and you met some other conditions, you would then get deferred action. DAPA was viewed very differently, right? DACA was a policy that was, well-liked because the kids had no blame, whereas in DAPA, the parents were not in the same boat. They did decide to come to this country, and perhaps it wasn't as popular. What happened? Texas and a number of other states challenged the legality of DAPA. They filed suit in a very favorable forum in the Southern District of Texas, and they argued that DAPA was a violation of administrative law, and they also argued that DAPA violated the take care clause of the Constitution, which is somewhat obscure, but got a little bit of a salience back in 2014. What happened? A federal district court in Brownsville, Texas, issued an injunction that blocked DAPA from going into effect. So DAPA never actually went into effect as it was designed to do. The Obama administration appealed that case to the Fifth Circuit. The Fifth Circuit affirmed the injunction. And they said that, number one, DAPA had to go through what's called notice and comment rulemaking. He had to go through this administrative process. And second, the Fifth Circuit held that DAPA was illegal, that it was contrary to law, that the executive did not have the authority to grant lawful presence to, say, 1 million DAPA recipients. Okay, what happens next? The case is appealed to the Supreme Court, and review is granted in late 2015. At this point, the Supreme Court had 9 members, but not for long. About 2 months after the Supreme Court grants certiorari, Justice Scalia passes away, which drops the court down to 8 members. The case is argued in March. I think we were there, right? I think that was the last time I saw him, but was that 4 years ago? Is that right? Oh boy, yeah. So I last saw him 4 years ago. Good friend I am, right? And the case was argued with 8 members, and maybe you have your impressions. It looked to me pretty tied, pretty sharply divided. And in fact, that's what happened. The Supreme Court split 4-4. What happens when the Supreme Court ties? You simply affirm the judgment of the Court of Appeal. So the lower court judgment stands. It doesn't set a precedent, it just affirms that judgment. So in other words, the Fifth Circuit's judgment stood, and DAPA was enjoined. Now at that point, I think I'm speaking for both of us, we both expected Hillary Clinton to win the election. Yeah. In which case, Merrick Garland, or maybe some other more moderate member we put on the Supreme Court, at that juncture, the 4-4 would become a 5-4 in favor of the policy. That did not happen. Instead, the escalator came down, and we had the election in 2016, and we got Neil Gorsuch, and we got Brett Kavanaugh too, and we have a different court than existed in 2016 when this case came up last time. All right, so fast forward to the Trump administration. Initially, President Trump said, we're going to wind down DAPA. Okay, no big deal. It never got into effect because it was always halted by the courts. But Trump initially said, let's keep DACA in place. I like the Dreamers. And they left DACA in place as it was during the Obama years. Enter Texas. Texas threatens to sue the Trump administration unless they suspended DACA on the same theory that they litigated the DAPA case. In 2017, Attorney General Sessions released a memo where he said, I am instructing the departments to wind down DACA. And he made a couple arguments. He said that he thought it was illegal. He wanted to avoid having to litigate this issue further. He thought the Fifth Circuit decision was at least, if not binding, persuasive enough to suspend the policy. He made a couple justifications. What happened then? Well, instead of Texas suing, now you have the blue states suing. And instead of suing in Texas, they sue in California, right? So now the blue states file these lawsuits, and they challenge the decision to rescind or cancel DACA, right? And they made a lot of arguments. First, they argue that the cancellation of the policy violated the Administrative Procedure Act, that you had to go through this regulatory process to wind down the policy. California and others also argued that the policy was illegal, right? Why? Trump has the authority to suspend the policy, but the reason given was what we call arbitrary and capricious. What's the argument? Trump said, we are ending DACA because it's illegal. That's a legal question. If it's legal, then they're wrong. Then the justification they gave is irrational. In other words, the reason they gave DACA being unlawful, if that judgment is incorrect, then the judgment given was arbitrary and capricious and cannot withstand judicial review. There are also constitutional arguments here. At least one federal court, maybe two, I'm blanking, said that the decision to wind down DACA violated the equal protection of laws. Why? The court said there's evidence that President Trump has animus toward Hispanics. And the predominant beneficiaries of DACA are people who are of Hispanic descent. Therefore, it's an animus-tainted policy, to use the lingo, and it violates the Equal Protection Clause. Okay. Without fail, I think almost every single judge but one ruled against President Trump. All the courts of appeals ruled against President Trump. And then the Supreme Court granted review. I hate to break it to you. Usually when the court grants review, they're going to reverse. Not always, but in most cases when the court grants review and there's no circuit split, that means they're going to reverse. So there's a good chance Trump wins this one, although I'm not exactly sure what a victory is going to look like here. I want to walk you through my sort of idiosyncratic approach to the case. The first issue is whether DACA itself is lawful. And I want to draw a sharp distinction. If DACA was merely a decision not to deport people, that's all it was, you give people a do not deport card, I think my argument would be a little bit different. Without question, the government has limited resources. They cannot remove everyone in this country. And if they want to deprioritize, say we will only remove certain people, I think that's on a very much stronger footing. But DACA goes beyond merely deprioritizing removal. I think where the policy goes into the abyss of powers is by granting what's called lawful presence, which includes work authorization. Without question, the laws allow the Attorney General, and now DHS, to give work authorization to people who are on deferred action. But historically, that number was very low. In fact, when this regulation was first enacted in the 1980s, a member of Congress asked the official, how many people do you think will get work authorization? And his response was, I'm paraphrasing, he said, the number is so small, it's not even worth keeping track of, right? It was meant to be a very small, stopgap, short-term measure for people who are in a tough spot. DACA is indefinite. In theory, you can renew it indefinitely for year after year after year and never have it removed. So I think DACA goes beyond the scope of delegated authority. There's a concept in the law known as the non-delegation doctrine, which is the idea that when Congress gives power to the executive, they must give a principle by which it can be enforced. The immigration laws give no hint that Congress wanted to give such broad authority. There's a very famous phrase that Justice Scalia originated. He says, Congress does not hide elephants in mouse holes. Right? What does that mean? When Congress wants to give a very big power to an agency, they have to do so expressly. Here, there's no express delegation to enact DACA. In fact, what are the statutes? One statute says the secretary can set priorities. Right? That's all it says. The secretary can set priorities. This sort of statute is not enough to support this ginormous delegation of power to grant up to 1 million aliens work authorization. Okay? But I think the argument goes beyond the text. DACA is also not consistent with past executive practice, right? In the past, deferred action was used as a bridge where, again, status was waiting at the other end of the rainbow. DACA does not operate in that fashion. DACA was enacted in the hope that maybe someday a statute would be enacted to give these people status. There was nothing waiting for the dreamers at the end of their status. It was merely just a hope that Congress would get its act together. It's a shame that it hasn't. So I think DACA is not consistent with the text of the Immigration and Nationality Act. Also, I think that DACA is inconsistent with past practice, right? Which means that I think the Trump administration was correct to conclude that DACA was contrary to law. But let's say I'm wrong, right? Let's say I'm wrong. Let's say that maybe DACA is legal, or let's say that maybe DACA is a close question, right? There are lots of hard questions where people disagree. Here you have, a bunch of federal judges said, we disagree. We think that DACA is legal, therefore Trump loses. Here, I think deference kicks in. And the topic of deference is one we hear about a lot. You may have heard of Chevron deference, right? What is Chevron deference? Have you taken admin law yet, any of you? Okay, you'll take it soon. Chevron deference is a doctrine of administrative law. When Congress enacts a statute and there's a term that's ambiguous, right? Think of like some complicated statute about chemistry or like biology, right? Which I can't explain. If you have an expert agency that interprets a term, an ambiguous term, the courts will generally defer to a reasonable interpretation of ambiguous statute, which maybe makes sense, maybe doesn't. That's not what I'm here today to argue about, right? But here we have a case where the executive branch is not interpreting some obscure statute on how many parts per million of pollution you can allow. Instead, the executive branch is interpreting its own duty of faithful execution. They're saying we think this policy is illegal. In fact, it says unconstitutional even. And when the executive branch comes in and says that a policy is illegal or unconstitutional, that's entitled to some deference. And I don't think a court can come in and say, well, you're wrong, so we're going to stop you. I think it just be a reasonableness judgment, right? Is this a completely unreasonable reading of the law? And there the answer is no. At least one court said a similar policy is unlawful. I think the judgment that they put forward is likewise unlawful. Now, the difficulty is the government's been sort of hesitant, right? The government hasn't actually come out and said we think this is unconstitutional. They sort of danced around that issue. But I filed an amicus brief on behalf of the Cato. Oh, where's Anthony? Where's your Anthony? Anthony worked with me back at the Cato Institute a couple of years ago, and now he's a 2L here. But I did an amicus brief for the Cato Institute. Did you do our DAPA brief in 2014 or 2015? Yeah, that's right. I knew it, yeah. So we basically recycled our brief from the last time we were at the court, just for a new one, arguing that the executive here, it would be unlawful to implement this policy, and that the court should defer to the decision now to rescind it. Now, where does all that leave us, right? The Dreamers are in a tough spot, and I don't want to minimize this. They're caught in between a very unfortunate situation. How so? They were given, not a promise, but they were given this sort of opportunity back in 2012, 2013, that if they were to play by the rules and pay certain fees and sign up for this policy, that they would be safe from removal, at least temporarily. And a lot of people relied upon that. It was always very clear this was not permanent, that could be taken away at any juncture, and I want to make that point clear. This was not a permanent decision. But fast forward to after the election of 2016, that policy was no longer set in stone, right? And the president tried to wind it down. And I don't know what happens in 2020 if the court rules is unlawful. Maybe the president strikes some sort of deal to give the Dreamer status. Maybe the Dreamers are given status as part of a bigger immigration package. Or maybe nothing happens at all and the election of 2020 decides it. I don't have any crystal ball. But what I want to leave you with, and I'll turn over to Anna in a moment, what I want to leave you with is this. You live by the pen, you die by the pen, right? The pen and phone, executive action. It's great when your person's in power, and it sucks when your person's out of power. This is why it's very dangerous for any polity, any republic to rely on temporary executive action that can be suspended by the predecessor. The way to enact meaningful change in immigration law has to be through statutes. It has to be through permanent legislation that has buy-in. Now you're going to say, Josh, there is no buy-in in immigration, it's such a divisive issue. You're right. And unfortunately, when you don't have that buy-in, you have just gridlock. And you have stasis. You have people who perhaps should be treated well are not being treated well. And I don't know exactly what will come of all this. But what I do know is that if the court rules in favor of President Trump, the Dreamers are a fairly vocal group. I think they're very compassionate. They evoke empathy in a very large regard. So I think the chance for legislation is great. But if we do get legislation, it should reaffirm that that's the correct path and not executive action. All right. I will wrap up here, turn over to my good friend, and I'll take some questions later. Thank you so much.
So I'm pleased to be able to respond to Josh's commentary, Professor Blackton's commentary on DACA, the litigation. So perhaps because I'm inspired from having recently seen Hamilton here in Philadelphia, I'm feeling very Hamiltonian at the moment. And so I want to look to Hamilton and the vigorous executive in defending the constitutionality of DACA, and then explaining why the rescission of DACA was not appropriately done.
So let me begin by, just before we get into the substance of this, mentioning that sort of one of the great privileges that I had as a law professor, probably the greatest privilege, and Professor Blackman, I think, as a policy matter agrees, and we concur on this, is having spoken to a group of new Americans being sworn in at the federal courthouse. And in the old vein of social contract theory, they explicitly consent in a way that none of you who are U.S. citizens in this room ever do. You get to be born here, and that's it. No one ever asks you, do you wish to become an American, and do you join We the People? But standing in that federal courthouse, I saw the oath being administered, and these people explicitly consenting to become a part of We the People. So let's talk about that path to becoming a part of We the People. Now, there are some points that I'm going to agree with Professor Blackman on to narrow the scope of our disagreement. And so to begin, I don't think it's legally justifiable to believe that DACA is a path to citizenship. That's not what President Obama ever said. It was implicit in the title that it is deferred action. It doesn't say for how long it's deferred, but implicitly, and that was as long as President Obama or a like-minded executive was inclined to defer that action. Why was it deferred action, and why was it lawful as a constitutional matter at the time the President proposed it? It was lawful for the following reasons. Presidents are vested with the executive power. That means that they have the duty to enforce all the federal laws that exist in the United States Code. And they're to take care that that law be faithfully executed. Now, the take care concept, which is one that is surprisingly under-theorized and under-articulated by the Supreme Court, I think includes the idea that a president can order priorities in enforcement. And so thus we see, for example, there's typically a case in Republican administrations, Sherman Act antitrust enforcement for the South, whereas other certain priorities are emphasized. And so President Obama decided to exercise his prioritization given scarcity of resources. I believe that the estimate that came from Department of Homeland Security is that if they wanted to, they could only remove 400,000 persons a year, right? So 400,000 was the budget they had been given. Well, sir, given that I only have 400,000 persons I can remove, and that the number of persons who are in the U.S. Without authorization, depending upon the estimate, between 11 to 12.5 million persons, we're talking about, I think, 3% or so. So there are certain people who are going to be of greater interest to me to prioritize with respect to removal. Persons who might be violent felons, aggravated felons. And then there are certain persons who present equitable cases that, frankly, I would be pleased if one day they could become U.S. citizens if Congress were to authorize such a path for citizenship. And so implicit in this constitutional power to take care is the ability to prioritize removal resources. And not only removal resources, but other resources. That is, Congress may authorize certain types of expenditures. At the end of the day, it's the executive office that gets to decide how those resources get allocated. And so I think that I agree thus far with Professor Blackman that it was constitutionally permissible, or would be constitutionally permissible for someone subsequently to order their priorities in a different way, and let me say maybe in a perverse way, that seeks to remove persons who are contributing to our society and who we would be pleased to have join us in the federal courthouse for their citizenship ceremony. So the problem with what President Trump did is in part a problem of administrative law, in that even if the president does have reasons that he could offer for why he decides to order his priorities differently, he did not offer those in the first instance. In other words, these were after-the-fact rationalizations that were offered for a policy decision he had decided on other grounds. The president has not been shy about his sentiment about immigrants generally, or again, as my colleague just mentioned, that many of the overland immigrants come from Mexico, Honduras, El Salvador, and Guatemala, and the Northern Triangle countries. I believe it's about 45% of visa, the persons in the U.S. who were unauthorized or visa overstay. The persons who came from other countries and flew here on a lawful status, maybe an F1, F2 student, and then overstayed their visas subsequently. And so, given that one is president, one has limited resources to allocate, is it not a reasonable decision on the part of the Obama administration to decide to exercise its power to forbear and choose more wisely who is really worthy of removal? And I think that yes, it was constitutional. I'm going to disagree with Professor Blackman in this sense. Is I don't think that President Obama claimed to be creating a durable space. I think it was understood, and it was a very great risk for anyone who understood that to go and give their biometric data to the Department of Homeland Security. It was a great act of faith in government to do so, because of the possibility that that very same information could then be turned around in an enforcement thing and be used by a different administration. So let me grant that it would be possible for the Trump administration to rescind DACA, but why it could not, or at least why it could be stymied in its efforts with litigation, is the principle that under the Administrative Procedure Act, that we hold agencies for the reasons that they have given, and in making those decisions to change from one policy to another, there would need to be some reasoned deliberation. Again, after the fact, yes, there are reasons that could be offered, that there is maybe enough uncertainty about the constitutionality that one would prefer to not live with the uncertainty. Maybe one, again, just decides that you have some other policy rationale that you want to go a different direction with it. I think that could have been the Trump administration's prerogative, but it didn't follow the requirement of the UPA for a reasoned deliberation. Now, did it actually create a status, a durable status? And so my friend was offered the explanation that the provision of employment authorization and legal presence constitute something that couldn't, that was basically legally binding, that would not permit, could not have been done without congressional action. And I think, again, we can think of enforcement of employment authorization as also within the ken of the president's take care of powers. In other words, the president could elect to take action that would effectively exercise forbearance. You know, there are good policy reasons for doing so. So fiscally, for example, I don't want persons to be here in the U.S. knowing that some time is going to pass and they'll be able to support themselves if unable to work. And so the argument would be that these individuals wouldn't support themselves. We don't want them to become charges of the state. And so in lieu of that, we will, in the same way that we elect not to enforce removal proceedings against these persons, we might elect not to prohibitions against working within the country without employment authorization. What else can I say here? So, implicit, I've been reviewing Josh's well-written amicus brief in the Supreme Court. Let me suggest and push back, and Josh, who is the constitutional law expert, will correct me on this. But one possibility is that maybe the president could be authorized under Youngstown just to keep the black television in one of two ways. The power either has to come from statute or has to come from the Constitution. Josh's focus is on whether it comes from the statute. My suggestion is it can come from the Constitution, and it can come from past actions taken by the president where Congress didn't rebuff the president in his efforts. And so in other words, this becomes something of a gloss on the words executive power and a gloss on the words faithfully to take care of it and to faithfully execute. And so under that approach, then, the president might have to go it alone without statutory authorization. Now, I don't acknowledge or admit that there is no statutory authorization. I think that the point that Josh makes in his amicus brief is that, if the alternative is that if, in fact, the Immigration Naturalization Act were to authorize this kind of power that would constitute an unconstitutional delegation, I think we have to take a look for a moment at what do we mean by the delegation or non-delegation power. Well, so that is a doctrine that has been moribund since largely 1935. So that is, there have been two instances where the U.S. Supreme Court has told us that Congress has given away too much rulemaking authority to the executive branch such that it would constitute an excessive delegation. And so, in disagreement then, I would suggest that given that 1935, which was many, many moons ago, is the only time since that the Congress Supreme Court has enforced the delegation doctrine, really it seems that there is pretty good space then for President Obama in the first place to have claimed that he had authority under the Immigration and Naturalization Act to act under his executive power. Okay. Josh, I'm going to give you an opportunity to respond to me, and then maybe I'll have a sir reply, maybe, or not. But thank you for the opportunity to respond.
It's always a pleasure to gain a friend. We agree on a lot, we don't agree on this, but it's always a good lesson that even where you disagree, you can still be cordial and respectful about it. When you feel like Hamilton, I thought you were going to say immigrants get the job done. That was a good way to start your talk. Good line from the show. Let's start with Youngstown, a favorite case of mine.
This, of course, was the decision about the steel seizure case. Of course, Youngstown considered, does the president have the inherent executive authority to seize a steel mill in Ohio, not too far from here? The court held he didn't. And Justice Jackson recognized that for domestic issues, domestic at home, the executive has no inherent power. Immigration is such an issue. I will concede the president has some authority over denying entry to people. This was a travel ban issue. In fact, I got in trouble saying I think President Trump had some inherent power to deny entry to people he deemed detrimental. But once you're here, the president doesn't have his own authority. He has to rely exclusively on legislative authority. And the entire concept of constitutional gloss applies to executive power, not legislative power. And this is a point I make in our brief, right? You cannot say, well, I have violated a statute many times before, that means I can keep violating it. That's not how it works. There are some cases where if a president keeps violating the separation of powers, you defer. It doesn't work for statutory authority. But let me take an issue more broadly. We both agree about prioritization. If DACA only prioritized people for removal, I don't think I'd be up here. I think it would probably pass muster. The issue for me entirely is about the work authorization. And the issue is whether the statute delegates enough authority to grant such a large number of people work authorization. Now, of course, I rely on the moribund non-delegation doctrine. But it's not quite dead anymore. There was a decision last year called Gundy. Not dead yet. It's like the parrot, right? Or Princess Bride. It's mostly dead, right? I think we're going to see a comeback to the non-delegation doctrine, and I'm pushing for it myself. I think Congress has ignored it for far too long. And in a case called Gundy last term, Justice Gorsuch suggested that we need to take a second look at it. I think Justice Kavanaugh is probably on the same page, as was Roberts and Alito. I think now you might have 5 votes for that position. Even if you don't go full hog non-delegation doctrine, the court does something that's similar to it. It's called the major question doctrine. And the court says that if you give us a reading of a statute that would violate the non-delegation doctrine, we just won't accept that reading. We'll say we will prefer a reading of the statute where delegation is more narrow. This was the so-called elephant and mouse hole theory I mentioned earlier. So I think it's possible the court says, well, we will not declare the INA unconstitutional. What we'll say is if we read the INA the way Obama wanted us to, then there's constitutional doubts. So to avoid those constitutional doubts, we'll read the INA the way Josh wants us to. No, that's not going to happen. But maybe, well, who knows? But we'll read it more narrowly, and that's how the policy survives. That's all I got. Want to respond, or we do Q&A, whatever you want to do?
Sure, I've got some responses.
Sure.
They'll just come up here.
All right, we'll share the podium left and right, I suppose.
So I guess my first response would be to the characterization of Youngstown. And so, yes, Youngstown, seal seizure case, the famous case you'll read about in Constitutional Law 1 for the 1Ls, you'll have that next semester. It does, in fact, concern the seizure of a steel mill in Youngstown, Ohio. Mm-hmm. But I don't read Youngstown to be limited in any way to matters that might, say, be characterized as either domestic versus foreign. One might note that subsequently, in a case called Dames and Moore, written by Associate Justice William Rehnquist, who had been a law clerk to Robert Jackson, whose famous opinion you study in Youngstown, adopted Youngstown in a case that was again, I think, a wholly foreign, or could be thought to be a wholly foreign, right? So we're talking about the rescue of Iranian hostages held by Iranians, and then issues relating to the settlement of claims and extinguishing claims that related. So, it's unclear to me that the characterization of Youngstown's examination is limited in that way. I'll note, too, that the Immigration and Nationality Act is something of curiosity. So, of course, those provisions of the Immigration and Naturalization Act that relate to naturalization are governed by our naturalization clause in Article 1, Section 8. But interestingly, there is no immigration clause in the U.S. Constitution. So if you look to Article 1, Section 8, there is nowhere enumerated the power. And so it's anomalous. So in other words, Congress is legislating without any enumerated power. And maybe a formalist should say, well, maybe we should amend that and give them an immigration power and in cabinet in certain ways. But in the absence, so what the court has done has recognized this notion that there's a certain inherent power that's inherent in the notion of sovereignty, and that because of this inherent power over sovereignty, Congress has power to regulate immigration. Well, so I think that's relevant because, again, that puts a lot of power, I think, in the hands of a president when you're dealing with control of the border, with many of these people never having been inspected or admitted, and that might be constructively considered to be, in some sense, at the border. And so I think President Obama then would have had authority And that would be consistent with the characterization of immigration power as one that is residing in sovereignty. There's something else you had said. I wasn't sure if I needed to respond to it. Maybe we just open up for
We'll
questions.
concede I was right.
Yeah.
We'll take some questions. Yeah, right over here.
Yeah, after I've read Gorsuch's book and I've studied him, I feel confident saying he would say he's a pro-originalist, anti-consequentialism, because the way he views everything is that if consequentialism will lead to opening us up to tyranny. You're opening ourselves up to putting more and more power in fewer people, allowing judges to interpret how they want to interpret and go that way. So what I'm getting at is I think with your argument and with, I believe, the way Gorsuch would rule, in the sense that you need the legislative process for the long-term strength of our democracy. So I see them reversing this case, but I would be somebody, I'll just be very open, I would be pro DACA legislation, but maybe I'm pessimistic with our politics. I don't see it happening. Why do you seem optimistic?
Oh,
about legislation?
I don't make predictions about legislation, but I think that if the court rules, then there's a window where something can get done quickly. And I think the political forces may come together for this narrow group. Or maybe not. Maybe I might be wrong. But I'm glad you read the Gorsuch book. It's a good book.
I might note that Justice Gorsuch, in replacing Scalia on the bench, I think moved the court in the direction, I think, of Josh's analysis, because I think Justice Scalia was not a big fan of policing the non-delegation doctrine. You know, for Justice Scalia, what was done in DACA, well, hard to say what he thought about DACA.
We know what he thought about DACA.
Well,
He told us
well,
in the Arizona case.
In Arizona, in his dissent,
he
he
said it was illegal.
Yeah, but this is where sometimes Scalia maybe disagrees with his own principles with respect to his application, because Scalia was decisionally cosmopolitan, and so things that might look like legislation that are done by the executive branch, Scalia very often would say, well, it's just executive power, but it's quasi-legislative. It's the magical incantation of quasi.
So a hand over there. Yes, over there.
So, Professor Sandline, you're talking about under the take care clause, discretion of the executive sort of direct resources and that 400,000 number. If we were to have a President Warren and take office in 2021, and as some of the rhetoric in the Democratic primary debate suggests, she declined to enforce existing immigration law at all, would that be inconsistent with the take care clause?
Yeah, so that a wholesale disregard of the immigration law. Well, so I think this is maybe where we get back to our pop-up discussion we had the other day, where we had a discussion about impeachment, right?
Oh boy,
yeah. And
that thing. Yeah,
and then it becomes sort of a question of what exactly constitutes other high crimes and misdemeanors, because that may be, the only sort of check ultimately that one has. So it's the political process, and impeachment is sort of in the modern era become a part of the political process, rather than one that I think should properly have originally been understood as something other than the political process.
Read the transcript. There it is. Okay. Another question. As people are shuffling for papers. In class coming up? Yeah, in the back.
Professor Blackman, you talked about how you could divorce certain policy and it be legal in your eyes. We also touched on kind of the nuance of that you seem to think that in this case, because it's illegal, the question of policy is good. Do you think of instances where, given the potential colorful aspect to the legality of DACA, the policy considerations outweigh what you think is illegal?
Yeah, and I think the issue is one of reliance. When you have the issuance of a preliminary injunction, one of the equitable factors is what kind of irreparable harm will this create? And to the extent that people have relied on it, that may factor against issuing an injunction. But I think here the case for legality is so strong that reliance, I think, has to give way. People are leaving, so come here. If you have questions, come up afterwards, but thank you all so much. Thank you. You got to run, right?
Yeah.
That's fun.
So I had a question for you.
Let me turn this off.